Yes, please be seated. Good morning or afternoon, Ms Halton. Thank you. And Ms Thornton.
If it please the Commissioner, I appear for Ms Holton. Ms Holton, you've received...
Oh yes, that'll be important. Do you wish to affirm or take an oath?
Affirm. Thank you, Commissioner.
If you would mind repeating the words after me. I, Jane Halton,
I, Jane Halton,
sincerely declare and affirm
sincerely declare and affirm
that the evidence that I give to this Commission
that the evidence I give to this Commission
shall be the truth, the whole truth and nothing but the truth.
shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
Thank you, Commissioner. Ms Holton, you have prepared a witness statement dated 19 October 2021 in response to the summons you received from the Commission dated 8 October 2021. Is that correct?
That's correct.
And you have a copy of that statement with you?
Somewhere here, yes. I've just been given a folder. Thank you. I do.
And that's a document bearing ID number CRW.998.002.0897.
Yep, that's correct.
And that's your signature on page 13 of the document?
Yes, that is.
And are the contents of your statement true and correct?
They are.
Commissioners, I tender that statement with its annexures.
Thank you, Ms Thornton. The statement of Jane Halton, dated the 19th of October 2021 and bearing the identifier number CRW.998.002.0897 with its annexure, is admitted into evidence as an exhibit.
Thank you, Commissioner. Ms Holton, do you have any comments on the Crown remediation program, particularly in respect of its progress to date and the ability of Crown to implement it going forward?
Thank you. A couple of things, if I might. The Crown remediation program, which has now been brought together in one, and it's a rather large document, brings together a number of strands of work, some of which predate the Bergen inquiry and the Bergen inquiry report, and some of which post-date the bringing down of that report. What the remediation plan covers are all of the things which we have determined and have been advised and have otherwise had encouragement to believe are the things that are necessary to put the company and its operations and the staff of the company on the right path in terms of all of the things that we would regard as being necessary for regulatory compliance and consistent with our social licence to operate. So it covers things such as AML, culture, issues in respect of governance, including the structure and composition of the board and senior management. In terms of our capacity to actually implement that roadmap, if I can use that term, I do believe we have the capacity to implement that. Now, some of the elements of this particular program of work, and I think we know this from other industries, take time. But I can say that there is an absolute determination to put in place the systems and the processes and the monitoring to ensure that happens. Some of those things have already been achieved, which I think you would know because of the items I referred to. We've already made substantial change, board composition, senior management, etc. But a number of those items are ongoing, but I am confident in the capacity to achieve them. Thank you.
So over the past year, there has been a refresh of the board and senior executives within Crown. Do you have any comments on what impact that has had and will have on Crown's operations and culture going forward?
Yes, I do. Thank you. A number of observations, if I might. And can I just say, I'm sorry, I'm getting an awful lot of noise from your end, people turning pages. I can hear rustling, scruffling, so I don't know whether people can either turn down the volume. It's quite distracting. I do apologise. So the people who we have been recruiting are people who have, firstly, extensive experience, credentials in a number of different areas, and who have, I think, a single-minded commitment to be part of the turnaround of Crown. And those people bring with them a mix of skills and experience. They bring literally turnaround experience. They bring professional qualifications, which are material in law, in accounting and all those other sorts of things. They also bring a level of goodwill, character, and I believe a way of working, which is very much part of the important component of our culture reform, which is about tone from the top. So they very much believe in walking the talk, being visible to staff, engaging with staff at all levels. They're all individuals who believe and practice respect in the workplace. And so they, in reflecting what I would regard as being their innate character in the way they operate, they've not only brought to bear those skills and experience already in the board engagements, but they're also demonstrating that, I think, in the way they operate and the way they engage with all of our staff across the organisation. Noting, with apologies to our WA colleagues, that not all of us have been able to travel there for quite a while.
And do you have any other comments on how matters are reported to the board and how the board is now operating in particular?
Well, other than the cultural components and the skill sets, which I've already referred to, what I would say is that the board is very focused on not just the broad sweep of strategy, but at a time like this, you need the board to be focused on detail as well. And again, I would say, and certainly one of the things I've been very keen to do since I assumed the role of chair, which is, of course, as everyone knows, in the interim, pending Dr. Switkowski's regulatory approvals, I've been very keen to ensure that we actually have, wherever it is humanly possible, documents with thought through argument and material, including facts and advice, in front of the board to facilitate those discussions. We've also been quite particular about ensuring that we have relevant expertise, which is outside the company, sometimes to enable us to test advice we're getting internally. And then I would also say that the nature of the people that we've recruited, all of whom have extremely, I think, credentialed professional business careers, those individuals, I would say to you, bring with them an informed but also a sceptical eye, which enables them to give advice, to think through, to look through the detail and work cooperatively with the board and, importantly, each other in assisting the board in coming to decisions.
Thank you, Ms Holton. Commissioners, that is Ms Holton's evidence in chief.
Thank you, Ms Thornton. Mr Futrell.
May it please, Commission. Ms Holton, can you hear me clearly?
Yes, I can. Yeah, I can, Mr Futrell. Thank you.
Thank you. Can I start by asking you some confirmatory questions around your previous statements to the Bergen Inquiry and the Victorian Royal Commission?
Sure.
You've mentioned in paragraph 5 you had regard to your
Five of which?
Of your statement to this commission that you have had. You've referred to it as your previous statement. Just to confirm, this is document CRW.998.001.0152.
Well, I'll take your word for it. I'm sorry. Let me just.
Have you got it in front of you, or does it turn up on the screen in front of you somewhere?
Hang on a second. I was given some things when I walked in here. I'm just seeing. Let me have a look. 28th of the 4th. Apologies, Mr. Futrell. Yes, that looks like the one. I've got it on the screen. Thank you.
Should be 25 pages in length.
Yeah, I'm sure that's true. Don't ask me to be entirely confident that 25 is right, but it wasn't short, Mr. Futrell.
Right. Have you had an opportunity to read over it before today again?
Well, certainly when I was compiling this other statement, yes, thank you.
And are you, I know it is dated, that one is dated the 28th of April of this year. I think you gave evidence, may have been in July, and I can't remember the exact date, in the Victorian Royal Commission, but are you satisfied it remains an accurate statement?
I think it's largely accurate, Mr. Futrell. I mean, I think as I've indicated in evidence in the Finkelstein inquiry, particularly in respect of risk and AML, the work on those elements of our programs have continued. So, and of course, a number of positions that were vacant have been filled since that time. So there are obviously some things which are dated. In terms of the major elements, I'm not aware of any error.
All right, I'll come to the updating a little later, if I may.
Yeah.
You are content though, at least the date of the statement, as of the date of the statements are accurate.
Well, and as I think I said at the beginning of that statement, there were a number of matters that I was asked to put in a statement on that well predated my time at the company. So, as I think I said at the beginning of that statement, I had to rely on discussions I had with people in respect of a number of elements on that in that statement.
Okay, can I take you to another statement of yours? This was to the Bergen inquiry. It's the second. You gave two statements to the Bergen inquiry. I'm interested in the second one, which is dated 13 September 2020, and it should have a CRL.693.001.0025.
Yep.
And in much the same, I don't know if you had a chance to look over this one. It's shorter. It's only 10 pages long.
No, I haven't had a chance to look over it. It wasn't on the list of documents that was sent on Friday night that you indicated an interest in going to, so I have not reviewed it. I've just been handed it as I walked in.
Okay, there are. We don't have an interest in every part of it. There are some paragraphs I'll take you to in due course. And
sure.
we can,
I may have to think about them, Mr. Futrell, but of course I'm happy to look at them again.
Yes. All right. Now, turning to your statement to this commission, I appreciate you've given many statements. Could I ask, just in respect of paragraph 12, you have given a brief overview of some of your professional experience that have exposed you to matters that are relevant to this inquiry, in particular harm minimisation and the AML CTF risk.
Yeah.
If I could just draw your attention to paragraph 12B, and you mentioned some experience you had when you were with the Department of Prime Minister and Cabinet.
Yeah.
What issues were you responsible for in that role on the interdepartmental committee that you chaired?
Well, Prime Minister and Cabinet isn't responsible for anything, Mr. Futrell. It's a coordinating department, so I think it's important to clarify the meaning of the word responsible for. That was a process of gathering together evidence and advice that was current at that time in respect of gambling in its broadest sense, including electronic gaming and including internet-based gaming, and what was known about harms, what was known about mitigation. And one of the things that was very clear at that point is there is no single source of truth. There are many sort of academic views and reviews on this subject. So this was a question of pulling together with experts in the field to provide advice to the then government on those matters.
So the interdepartmental committee didn't commission any of its own inquiries or reports?
No, but it brought together relevant experts to discuss their respective views. For example, on things like, and these are now matters of ordinary course, access to where teller machines, ATMs, might be proximate to gaming floors, issues around knowing what the time is, clocks, things of that sort.
And was there anything in respect of the information you came to your hand in that role that has informed you about how the effectiveness of the Crown Resorts harm minimisation program?
Well, certainly, I mean, when I joined the board, it was at the point of the 6th review, Mr. Futrell, and you'd know the recommendations from that. And so certainly the need to stay current with research, noting that, you know, we learn more as we go along, was part of the understanding that I had. And of course, and I'm sure we'll get to this, that was the reason that the independent panel was formed, to ensure that we had the most current advice. I mean, as you would also know, that I wasn't a member of that particular subcommittee. That committee was chaired by somebody else. But yes, in the broad, it did inform me.
Okay, and then can I just, I appreciate this is at a relatively general level. There's, in paragraph 12, C, you've mentioned a role with the Department of Health and Ageing, and you came across some information in that role concerning addictions. What was there anything specific about that concerned addiction in the gambling area?
Addiction in the gambling space, Mr. Futrell, isn't something that the Department of Health is responsible for, but addictions tend to be comorbid. So people who have dependencies will often have one, not just one, but will have several. And the antecedents, while they may not be the same, certainly this issue of comorbidity is something which is, I think, pretty well understood and acknowledged in the literature. The challenge is often treating people who have comorbid conditions, because the treatment services tend to specialise in one thing or another. And certainly addictions, and we can talk about that in some detail if you wish, but addictions, to the extent that you have one, you may have another.
And insofar as your experience in that role is concerned, does that provide you with any particular insights into the way in which Crown Resorts delivers its gambling services?
Well, I would say my professional background does provide me with some of that, Mr. Futrell, yes.
And have you been able to bring those insights and experience to bear in terms of consideration of the responsible service of gaming program for Crown Resorts?
Well, as I said, that committee wasn't a committee I was a member of, so I had an oversight role in terms of from the board. And as I've already said, because, as you know, there was an expert committee impanelled to actually give us that up-to-date advice, I wasn't involved in the day-to-day work, but I was certainly interested in watching what the expert panel were doing.
Okay, and in 12E you've mentioned your role at the ANZ, and you have significant experience with respect to the management of AML and CTF risk. The use of the word significant there, is that what's...
Significant time would be significant in terms of depth, well, to the necessary extent of a director, but over a period, and not just my period at ANZ, but obviously my period in the centre of government, looking at legislation, etc., in those respects.
And if I could just break this up into periods, in the, if you like, the pre-Bergen period, pre-Bergen inquiry period, was your level of experience relating to AML CTF risk in the casino sector of the same level as that for the banking sector?
No, clearly not, Mr. Futrell.
And has that position changed since the Bergen inquiry report?
Well, so there's two things that have happened since the Bergen inquiry report in respect of AML, if I might. The first of which is that, as you would know, the designated entities in terms of AML responsibility under the AML CTF Act were at the facility level. Those responsibilities were owned and were to be discharged by each of those entities. Since the Bergen report, we've actually formed a designated business group, which means that responsibility now sits with the CRL, the Crown Resorts Limited Board. So that's a particular change. And certainly, I mean, I would say to you that over a period, courtesy of not just the Bergen report, but a number of other instances, I was taking more and more interest even though at that point it wasn't technically something under the CRL. Well, it was under the umbrella, but we weren't directly responsible. I had been taking more interest in some of those elements, yes.
So do you mean by that answer that before that's Crown Resorts implemented the joint AML-CTF program more recently, you saw responsibility for the management of AML-CTF risk to be at the what you might broadly call the Crown Perth and Crown Melbourne level of management?
Well, it was under the legislation. So there was a kind of overarching reporting requirement, and there were, reports given and assurances given in respect of compliance in those respects. But it wasn't being, can I use the word, not that from a governance perspective, a board runs something, but it wasn't being run by CRL. It was being run by Crown Melbourne and Crown Perth.
Okay. I want to come back to the extent to which, in the course of your directorship with Crown Resorts, you've received additional briefings or training in those areas. But before I do, could I just ask you a couple of questions around your appointment? At the time of your appointment, did you have then any associations with any of the then current directors of Crown Resorts?
Can you define association, Mr. Future? Or maybe I should tell you what I knew of them, and then you can tell me whether that constitutes association. I had worked with one of those directors, Professor Horvath. I had met Ms. Coonan. I had met Mr. Demetrio. I had not met, I don't think, any of the others. Oh, I had met Mr. Mitchell previously in the ordinary course of my other employment.
Yeah, what I meant by an association was some sort of ongoing either professional or personal relationship with any of them.
Well, Professor Horvath worked for me for quite a number of years, and so to the extent that there is a relationship that comes from that, the answer is probably yes. In respect of all the rest of them, no.
Okay, so then it's probably answered my question, which was in paragraph 15 of your statement, you have indicated that excuse me, you don't have any. You've got use the word current associations with Mr. Packer or companies or people associated with Mr. Packer.
Correct.
Do I take that from that answer to mean that your past associations were, if you like, in passing with the members of the CPH board who were also on the Crown Resorts board?
No, actually, I don't think. I might have met Mr. Packer, seen Mr. Packer once somewhere with one other board member, but no, what I was actually referring to there was in the ordinary course of my role as a secretary of a department, I would occasionally see him at things.
I see.
In large situations, if that makes sense.
No, it makes sense. Thank you, Ms. Holden. Can I now just return then to the question of, and this is dealt with in your statement as well, in paragraph 18, where you've indicated that you've received a number of formal and informal briefings.
Yes.
I just would like to ask you to expand a little bit on that with respect to beginning with responsible service of gaming, and if you could provide the Commission with a sort of a more detailed explanation of the nature of the briefings you've received in that area.
Yes, on responsible gaming, I recall having received a briefing from both Professor Horvath about the work that was going on in the committee, including the panel, which I've already referred to, and then also from other members of the staff. I don't know that I can recall completely precisely who that was given by, to be honest with you. It was some time ago. I want to say it was Ms. Bow, but I don't want to say I'm confident in that memory. And then there was briefing given to the board on the odd occasion about where the panel was up to.
So are you drawing a distinction there between, say, for example, if you like, induction. As you joining the board, you receive some more intensive briefings.
Yeah.
And since you've been a member of the board, from time to time, there have been briefings that have come to the board in your role as a director, essentially.
Yeah, that's correct, Mr. Futrell. And I mean, one of the things that I have done since becoming a member of that committee is I have met more directly with all the relevant people. So met with the people responsible for RSG in Sydney, actually sat in on training sessions with them. I have met with the chair of our independent panel to discuss with him his report. I've met with Mr. Blackburn to discuss matters in that respect. I've done a number of things, so I would draw that distinction.
All right. So, when did you become a member of that particular committee, the Responsible Service of Gaming Committee?
Basically, when we had to become a member of everything, Mr. Futrell, because there was nobody much else. Now, I think my statement will give you the date, and I will mislead you if I don't look at it. I want to say it was earlier this year.
All right. No,
yes, March of 2021.
Okay, we don't need to be precise, Ms. Holder. It's just the point is that it was earlier this year when the board was under a restructure, if we put it that way.
Yes.
Okay, and do I take it then from one of your earlier statements about the restriction on travel that you haven't had the opportunity to familiarise yourself deeply with the program in Perth?
No, but what I can tell you, I mean, and sadly, I did come to Perth last year, but was locked in my hotel other than when I was allowed out for other work purposes. So I've not had the opportunity to visit the Perth site, sadly, for a while now. What I have done, though, is I have obviously had the opportunity to see some of the staff from Perth, using this kind of mechanism in meetings. I've certainly familiarised myself with proposals in respect of the Responsible Gaming Centre, things of that sort.
All right, thank you. Now, if we could turn now to deal with the AML and CTF thing, which obviously has been a topic of some interest for Crown Resorts for probably more than a year now.
Yes.
Could you break it up again in terms of, on induction, briefings during the course of your directorship, and then perhaps more recently, the level of and nature of any instructional training received in that area?
Yep, thank you. So on induction, there was, if you like, an overview of the programs that were operated across both the facilities, including things like, reporting of IFTs, TTRs, all the things you would expect to see, the kind of numbers that were involved, the number of patrons that were covered off by those matters. There were, as I think I've already said, a number of reports to the board about those matters. Now, as I think I've already indicated, that level of inquiry became sort of more intense, if I can use that word, after a period, certainly from myself. And I think what I would say is there was then structured training provided. That's been principally on the watch of Mr. Blackburn. And one of the things that he and I have talked about is the approach, and certainly since I've taken over as interim chair, the structured approach to that training, including for incoming directors. So there is, as you probably, I know you've taken evidence on the electronic programs that are available, those training programs that all the staff don't, I've done those. But then there's the more tailored training, which has been delivered more recently.
The online training is not really something you'd expect would equip an incoming director with enough information about all of the potential pitfalls of AML CTF risk, though, is it?
No, it isn't, and that's why there's a structured process which includes Mr. Blackburn taking each of the incoming directors through in some detail the approach that we take, and in the current context, obviously it's in the context of the rectification program. So there's a one-on-one session with each of those incoming directors. Now, some of those directors actually already have a fair level of familiarity with both the legislation and the requirements. And now, not all of them in a casino context, to draw that distinction you made earlier. But that is one of the reasons why we've now got that program structured. And that program will, as I think someone's probably already told you, but if they haven't, I'll just make the point, will also include that refresh of directors over a period.
Oh, I see. You're not refreshing the directors themselves, but refreshing their...
Oh, sorry.
Their knowledge. Yes, yes, understand.
Yes, apologies.
All right. Now, one of the questions we asked, you've indirectly answered, is question of what ongoing other areas of professional development the board undertakes. Has there been a program in place for that kind of activity during your the period you've been a director of Crown Resorts?
Not in the first instance, which was a surprise to me, Mr. Futrell, but there is now, and in fact I've had several looks at it in terms of the elements, and in fact I was only talking to Mr. Weston about this a matter of a week and a half ago, in terms of a refresh on that program, including where, for example, things like ethics training will sit. So there is that's one of Mr. Weston's jobs, is to make sure that it's structured and systematic and is sufficiently comprehensive.
And will that encompass what all members of the board?
Yeah, absolutely.
And will that also address any aspects of the, if you like, the matrix of skills as well?
It depends on what you mean by that, Mr. Futrell. Can you just elaborate what you mean by matrix? It can mean different things to different people.
There's a skill matrix referred to in the annual report. You may refer to that.
Yes.
And obviously not all directors have skills in all areas, but is the idea that the professional development program will be tailored to strengthen any deficiencies there may be in the matrix?
Can I answer that in two ways? I mean, I don't see the skills program as turning someone who, and I might use this term given the audience, I don't see it as turning someone who's not a lawyer into a lawyer. But what I do see it as making sure is that people have a contemporary understanding, for example, of the regulatory context in which we operate. We do need to make sure, and we all know that laws, regulations, community standards, they all change. And also you forget things. So it's important to keep people refreshed. So it also, I think, should be designed to challenge people in terms of how they also challenge, perform their role as board members. And we also know that the view of what being a board member is has changed very substantially to being much more engaged and challenging, and sometimes having to step into the breach. So it will be and is in design all of those things.
All right, thank you. Can I just ask you again, this is just to tease out in a bit more detail what you're meaning. So in paragraph 26 of your statement, you've given some information about the role you've been engaged in as interim chair. And can you just let us, if you don't mind, explaining what you mean by working directly with senior management? What are you getting at there?
Well, I mean, you have to be careful about, as a board member, not being in management, although there have been occasions over this last year where unashamedly, as directors, we've had to do some of the tasks that you would otherwise expect of senior management. But what I mean by that is showing leadership, engaging with the relevant senior managers on matters of judgment, in order that we can then form a view, bring matters towards the board, coaching, for example, on how to best bring a paper to the board so the board can do its job most effectively. Issues in respect of judgment. I mean, I talk to Steve Blackburn, I won't say every day, but it's close to every day. Steve Blackburn pretty regularly as well. I mean, I think the role of the chair does tend to be much more day-to-day engaged with senior management. And I think the point I'm making there is I've stepped into this role in the interim of chair, and that's working with those senior managers. That's what I've been doing.
Right, thank you. And there's also a phrase you've used, which is communicating with all staff.
Yes.
In relation to Crown's change agenda. What do you meaning there? In what way do you communicate with all staff?
Yep. So one of the things I was very keen for us to do through February, as things were unfolding post the Bergen review, was to ensure that there was a clear line of communication, certainly from the board through to staff. And I encouraged Ms. Coonan to actually put out regular communications since I've taken over as interim chair. And I've done this mindful of not wanting to bombard staff with, too many emails and too many videos and too many whatevers. And the way that the approach to communicating with staff has been organised. So I have been sending out a monthly communication from the chair. So I've done 2 of those. I've been in this role now for 2 months. I've sent out 2 of those emails, just talking about what's going on. Obviously, it's been a difficult time with close down, obviously not in WA, but for Melbourne and Sydney people, that's been pretty tough. So everything from acknowledging what people have done a really great job on. So, for example, the telethon AFL work that's happened in WA. So looking across the organisation, what people have done right across our facilities, but also talking about what's happening in our corporate life and what's also happening in the broader, wider community. And it wouldn't surprise you, I think Mr. Futrell will know, talking to them about vaccination.
Okay, and the expression Crown's change agenda, is that shorthand for remediation plan, or is it wider or broader than that?
Well, I think nearly everything. I don't want to make a kind of inclusive statement and miss something, Mr. Futrell. A large proportion of what we're doing is in the remediation plan. That is true. It's not only in the remediation plan. So there are some things that we're doing. And actually, I've mentioned vaccination. That's not part of our remediation plan, but it's part of our change agenda. It's part of our corporate social responsibility. It's about protecting our staff. It's about protecting the community. So it's about all of the things that we're doing, both in the remediation plan and elsewhere.
Right, thank you. Now, in this part of your statement, you have made a number of references to the board. This is in paragraphs. Really, I'm focusing on 29 and 30 at the moment.
Yep.
Which obviously is the collective.
Yes.
What role do you see yourself as the individual playing in bringing about, in specifically each of the matters you've identified in paragraph 30?
Well, can I put all of this, Mr. Futrell, in an overarching context? And that is, I think you have to practice what you preach. So when we talk culture, and I've already started, I think, in talking even about the emails, the newsletters that I put out, it's about demonstrating that we are talking to people across the organisation. In terms of my engagement with these things, obviously, I'm very much at the moment hands-on, trying to guide, steer and engage in the development of everything that you see on this list, being actively engaged, talking to staff. Now, again, acknowledging that that's been difficult in the last 3 months because of lockdowns, but looking at the continued need to drive change, and each of these categories are things that I have been actively engaged with.
What I'm interested in, you'll see this in a number of the respects you use the word ensuring, and how are you able to give us an indication of how you see yourself as if you like the assurance agent, if you like?
Yeah, thank you. So 2 things. The first of which is inquiring, examining and testing the material that is brought in front of us, including for completeness. So it's not sufficient to just deal with matters that are served up to the board to say whether they are adequate or not, or in between, but also to think broadly about whether we have covered enough matters and domains to actually put us on the path that we need to be on. And the ensure part of it is not just assuming it's done. And I think that's probably one of the deficiencies that I would say that I think probably wasn't evident to me early on in the piece, actually making sure that there is a mechanism. When I was an executive, I had what I would describe as a resubmit system. It's when is this being reported back? How are we holding people accountable? And are we satisfied with the outcome once it returns and once it's in theory been delivered?
In that answer, are you alluding to the possibility that perhaps the earlier manifestations of the Crown Resorts Board was not doing enough of the ensuring or testing of the management?
I think sometimes testing, but I do think on reflection, Mr. Futrell, that even when those tests were applied later, there probably wasn't enough third-party validation that actually went to the heart of the issue that actually should have given confidence.
And do you see as part of the role of the director to, if you like, remain somewhat sceptical of what the management may be providing to you? Very
much so.
Is that something perhaps you've learnt more readily, a harder lesson to have learnt more recently, perhaps?
Mr. Futrell, I think you would describe me as being always relatively sceptical. It didn't make me a lot of friends amongst some of the former management.
All right. Can I turn now just to ask you some broad questions around the topic of governance, which is of some interest to this commission.
Of course.
The remediation plan, no doubt you're familiar with it. I won't take you to it.
For the record, yes, Mr. Futrell, I was just nodding. That doesn't do for the record.
And there was some work done, obviously, perhaps earlier before the Royal Commission in Victoria and Western Australia began, on centralising the management and control within the Crown Resorts Group.
There was some work done by a couple of members of management on that. That is correct. And
there's an indication in the current version of the remediation plan, at least the one I've read, that process is under reassessment at the moment.
In fact, the one I've most recently read, which is the one dated I think the 30th of October, I can't say that I remember seeing it there, Mr. Futrell.
I see. I don't know that I've received a copy of that one yet. It's probably...
I may have missed it because it's not a high priority, but I suspect you're going to want to talk about that, so please let's do.
So yes, the copy I'm working off I think was at the end of September, but perhaps the most recent version hasn't made its way to the Commission yet. What I'd like to do, if it's probably easiest to do this by reference to, you might recall you received some topics with your summons.
Yes. Now, I don't know that I've got those with me, but anyway, let's see if I can remember them.
I can get them up on the screen. It's PCRC .0002.0029.0008.
Yeah.
And I want to take you to question 37, or topic 37, which sets out in a summary way the somewhat complicated legal framework that operates in Western Australia.
Yep.
And I take it you have at least a working knowledge or a familiarity with that structure?
Correct, Mr. Futrell. I mean, and let's be clear, I'm not a lawyer and it is working. Yes. Not forensic.
I just want to take you through some elements of this, the framework here, and then I've got some questions for you of a fairly general nature, but to get your views on essentially the structure.
Sure.
And potential changes or possible changes in the future.
Certainly.
So the next document I need to show you is the constitution of Burswood Limited, which is PUB .0026.0002.0001. And if we could navigate to pinpoint 0010. Now you may recall one of the questions you were asked amongst the topics concerned Article 3.12, which is at the top of the page there.
Yes.
What wasn't drawn to your attention at that time, but I would wish to draw to your attention now, and you may have some familiarity with these provisions as well, are Articles 3.19 and 3.20.
Yes.
So
Can someone put 20 up as well for me,
yes,
please?
if we could actually have them all three together, would be brilliant if that can be done.
I'm glad it's not me driving this, Mr. Futrell, because I would fail at this point. There it is. Brilliant. Well done, whoever that is.
Okay, now
Yeah.
putting the three together, and again, I'm not asking you to be a lawyer. This is just a general proposition I'm putting to you.
Yep.
Would you accept that one view you could take of those provisions collectively is that there is one of the purposes or objects of having 3.19 and 3.20 is so that the Western Australian regulator is in a position to ensure that the company is carrying out what it should be carrying out under 3.12.
Well, amongst other things, I think that's probably...
Amongst other things, that's right.
Yeah.
But it injects into the boardroom of the local company the regulator, which is an unusual circumstance.
Oh, I don't know if it is particularly unusual. I mean, but anyway, the opportunity for regulators, should they so choose, to attend a decision-making forum, I don't know that I would regard as being very irregular, but...
Okay. In any case, that is the case here in the Constitution. Correct. And you would also, and this goes back to the topics, you'd be familiar with that fact that the licensee in West Australia is actually a company called Burswood Nominees.
The licence is held by the trust, am I right in thinking that?
Yes, yes, that's right. And the trustee of the trust is
owned by Burswood Nominees, yes. And
that company is a party to a state agreement in Western Australia.
Yep.
And Burswood Resort Management is also a party to the state agreement, and it's a manager under the trust deed. So there's an
equivalent, so to speak.
That's right. And while Burswood Limited, that's the company's constitution we're looking at here, is not a party to the state agreement, it is, of course, the owner of the trustee and the manager. Mm-hmm. And we've, in the topics, we've also put out some features of the trust deed and how that operates. What I want to put to you is having sort of, this is a long lead up to the questions you got asked about the position in Melbourne, where there is, and again, this is dealt with in the topics, there's the management agreement in Victoria that has some provisions that, if for want of a better way of putting it, create a bias towards maintaining Crown Melbourne as the flagship for the Crown Group, and also there's one provision that deals with running businesses within Australia in a way that's beneficial to tourism, etc., in Victoria. Now, again, I'm not going to ask you to answer the questions as a lawyer, but simply point out or ask for your view on whether, in that context of there being a particular regulatory regime in Western Australia and another regime in Victoria that requires certain provisions to be adhered to by Crown Melbourne, would you accept that in that framework there is the potential for there to be a conflict of interest between the local Western Australian company structure, Crown Perth Group, and either Crown Resorts as a whole, or either Crown Melbourne, or when it's up and running, Crown Sydney?
So there's a lot in that, Mr. Futrell.
Yes.
Can we unpick it a bit?
Sure.
Yeah, I just, because it strikes me that you can't give just a narrow answer to that question, and I'm conscious of not talking for too long at a go. Can I first deal with flagship?
Yes.
So I may be boring and old-fashioned. As far as I'm concerned, flagship literally means the biggest ship in the fleet. And that might be my English heritage, and maybe it has a different meaning in more common parlance. But to my mind, it is the biggest ship in our fleet. And it strikes me that in a city of 5 million or whatever it is at the moment, on the East Coast, where the majority of our international visitors arrive, as opposed to Perth, which is a very proud and independent and fabulous city, but it is much smaller. And so I have never seen that particular provision, the Melbourne provision about flagship, as being inconsistent with the priority that we rightly give to the other properties that we have. And in fact, and I gave evidence about this in the Finkelstein inquiry, and because I have, and I'm now again, I took on the chair of Melbourne role when we extracted the Melbourne directorships from management, when it became a property that was going to be opened and then it had independent directors on it. And the question of whether in fact all of the properties are advantaged by being in a group, as in it's accretive, as opposed to it is diminishing for the smaller properties, is something which I was quite concerned to understand. And all of the understanding that I have, and this is both from talking to people who understand particularly the casino trade, and also based on my understanding of other businesses, but also my understanding of running very large organisations, that there are distinct advantages to actually having membership of a bigger group. And in this case, and as I'm advised, the way people move around properties, particularly if they come to Australia, that actually being part of a group is beneficial. So to my mind, there is not an inconsistency. Now, we can have a conversation about those clauses and the running of the WA business, and we should have that discussion, I think. But to my mind, it's not fundamentally inconsistent, and I don't see it that way. And certainly that's all the advice I've had when I've tested this.
All right. Leaving to one side the potential economic benefits to the group as a whole of operating in a group structure, the point of my question was really more directed to the potential for there to be, even within that, if the group, what's good for the group is good, it may not be good for one of its members. So there's a potential, just leaving it aside, one can foresee the potential for there to be some interests that don't coincide.
I struggle to see what they would be, Mr. Futrell, to be honest with you. I have thought about this quite carefully, and I had to think about this particularly in respect of the agreements in Sydney, where I'm on the board of the subsidiary, and to try and, I've met with the regulator there quite recently to try and think how there might be an inconsistency, particularly if you do have the capacity to exercise responsibility in respect of that business in its legislative context, in its community context. So I struggle to think about what those might be, to be honest. Maybe that's a lack of imagination.
Are you resisting the idea there could be a conflict, or are you saying you can't foresee one?
I can't really foresee one. I'm struggling to foresee. Now, I know there is a suspicion about that, but when I sit and unpick it, I really struggle to think of where there might be a conflict. And take the example, and I don't know whether it was given here or whether it was given somewhere else, of staff. But let me give you an example of where actually it's to the advantage of Perth. So we have, as you know, some roles that are undertaken for the group and some roles that are undertaken for the properties. And in this particular instance, one of the roles that was undertaken for the group, which was being undertaken in Melbourne, is now being undertaken in Perth. So a national role is being undertaken out of Perth. Now, that's not the first time, but this is, again, a notion that this is actually to the advantage, not the disadvantage of Perth. Anyway, as I said, I struggle to think in practice. I mean, I'm not saying that you wouldn't acknowledge the potential, but I struggle to see what they would be in practice, Mr. Futrell.
Okay, well, if you acknowledge that there's at least a theoretical possibility of interests not coinciding.
Well, there's always, I suppose, a theoretical possibility. My absence of imagination doesn't eliminate that, Mr. Futrell.
No, so I'm happy to work on the theoretical rather than the foreseen. If one takes into, and again, there'll be a build up to this, Ms. Holden, before a question arises, but I'll just take you through the build up first. The taking into account a few things which I've covered a bit already. One is that Burswood Nominees is the licensee, and that gives it a particular. It has particular obligations then to the state of Western Australia under the regulations here.
Yes.
The second is that, as I said earlier, that there's a state agreement that Burswood Nominees is a party to and the manager's a party to. But obviously, Crown Resorts is not a party to that agreement. So Crown Resorts does not owe any direct contractual obligations or legislative ones to the state of Western Australia. The third is that effectively Burswood Nominees and the manager, Burswood Resort Manager, are controlled by Burswood Limited, that's the company. And the fourth is what we've just accepted, or I think you've accepted, there's a theoretical possibility for the divergence of interests within the group. And now, in that context, would you agree, or what's your view on this proposition that, in that context, Burswood Limited's constitution, and in particular Article 3.12, means precisely what it says, that the place where central management and control of Burswood Limited and that group is to be exercised is Western Australia, not management from Victoria, not control in Victoria, but Western Australia?
Well, Mr. Futrell, what I'd say to you is, and it is a question of the definition, isn't it? I mean, I actually think, and we should come to the question about what functions you might adopt because it's to your advantage that are delivered on a national basis, noting that, for example, the legislation that applies to AML-CTF is national legislation. What I would say to you is, I mean, my reading of that, with the disclaimer I'm not a lawyer, is that actually the head office for this company is in Perth, and it is operated by executives from Perth, that day-to-day management decisions, as far as I am aware, are taken in Perth. There are risk people in Perth. There are second line AML people in Perth. There is actually going to be a research, I don't know that they've actually recruited, I think they may be close to it, a research person on AML, not AML, an RSG in Perth. And to go to the point you make about obligations owed by, for example, Burswood Limited, and noting, if I might, that I don't believe, I mean, Crown Resorts has owned Burswood, but it's not the first owner of this company, as I understand it, sole owner. It was formerly a listed ownership. This is not a new issue, if I might make that point. But there's no reason why Burswood Limited couldn't be a party to the state agreement and be explicitly rather than implicitly bound by it. I mean, I would argue to you, and certainly I believe it to be the case, that the company behaves and believes it is bound by that agreement. But it could be explicitly bound.
The point of the build-up, Ms. Holt, wasn't so much to draw a distinction between who the parties were to the state agreement, but to emphasise that there is a geographical provision in the Constitution that, when combined with having the regulators having the ability to participate in the meetings, one could strongly suggest that the locus of the decision-making and control for all things relating to Burswood Limited and Crown Perth should be Western Australia.
Well, look, it is absolutely the case, and I completely agree with you that the day-to-day operation of the business should continue to be managed from Perth. There's no doubt about that. The company was taken over by another company, now publicly listed, which had a national footprint. That was approved by the government of the day. Now, this constitution, I think we all acknowledge, is quite old. It's got provisions in it that have not been changed. The reason for that I do not know, but I do not believe that it is inconsistent with, and certainly the way the current board intends, that there be a properly functioning board in WA operating the business in the way that we would expect of a board. And I know Mr. Carter has spoken to you about his view about how boards, etc., should operate, and I fully support the views that he put to you.
All right. Can I want to come, but you mentioned earlier some questions that were put to you by Commissioner Finkelstein. I want to come back to those because they can be put to you equally, I think, in our particular context. But before I do, can I just traverse some of the ground you've covered? Partly dealt with. And this turns on how Crown Perth is actually governed in practice. So, you might recall you asked some questions around this topic or that subject matter in the topics we sent to you. And in paragraph 45, you've indicated that it operates in the way you would expect a board of a subsidiary of an ASX-listed company to be. And are you able to elaborate a little bit on what you mean by that?
Yeah, I can. And I should say that essentially, and again, this is reflected in what I'm expecting of what is the case with Sydney, noting that there is no gaming in Sydney at the moment, so the operations are not directly analogous. But decision-making and looking at everything from occupational health and safety, the compliance with the local regulatory arrangements, and you rightly had someone pull up before that provision that the regulator is invited to attend. My understanding that those invitations are now properly being issued, which clearly they weren't, and that's not okay. It has responsibility for looking at employment, looking at the implementation of arrangements in respect of AML, RG, etc., being connected to the local community, acknowledging that every community in which we are located is a different community, and the expectations of us and our facilities in those communities will differ by part of geography and by part of size, but also in good measure by the nature of the cultural context in which you operate. So you get different state laws. Employment law is different across the states and territories. So that board has to take those responsibilities. And again, as I said, I've talked with Mr. Carter about ensuring that that is seen to be and is properly undertaken.
All right, this might be a little bit along the same lines, Ms. Holden. If I could draw your attention now to 46C of your statement, where you've indicated the involvement of Crown Resorts in the governance of Crown Perth. And
so can I make it, I don't want to interrupt you, Mr. Futrell. The introduction to that paragraph says governance or operations.
Yes.
And I think C is an operational issue.
Okay, so thank you for that clarification. So can you expand or explain what you mean, or what 46C means in practice?
Yeah,
How it happens in practice.
Sure. So one of the things that is an advantage to an enterprise if it's relatively large, and this is an advantage both in financial terms but also operational and regulatory compliance terms, is to ensure that it builds the most effective systems that it is able to. Now, in some instances, the regulatory context is different on a state-by-state basis, and that's not impossible to manage. And clearly, you have to have these matters adopted by each jurisdiction. It's not a matter of fiat that these things, they're not mandated by the centre because of the decision-making responsibility of boards. But programs that are pretty usually jointly developed and then implemented across a group, in my experience, give you a greater level of comfort in terms of their effectiveness and their efficiency. But they also mean that you're more likely, if we take regulatory compliance, to be compliant. And AML-CTF is a good example of that. These are very big, extremely complicated programs to run. And what you want when you're running those sorts of programs is not to build systems, both in terms of, by that I mean IT systems automation, but also the instructions that underpin those systems. You don't want to build those 3 times. They're expensive. But what you do want to make sure is that you use the expertise of all of the people in your purview, in your group, if I can use that term, to ensure that what you build is fit for purpose. So that's really what that's talking about. And I think I mentioned earlier that the person who's now head of IT for the group is actually located in Perth. So the people in each of these locations work very closely together on these things in order to actually develop systems that are then able to be used. I used to say, Mr. Futrell, when I was in management, develop once, use often.
Is it, and I'm just trying to get a sense of what you're meaning. Is it the case then that, and I want to try to work out the demarcation here between what Crown Resorts Limited does as a board and what the local board would do. So insofar as the development of the overall framework goes, if I understand your answer correctly, it's driven largely by the economic benefits of efficiency in terms of you do it once, in a way that is uniform.
That's not just an economic benefit. I said economic benefit, although I didn't use that term, is one of the benefits. The capacity to have assurance around develop once, use often is also part of that. It also means that you can streamline everything from training through to, I mentioned before, assurance systems. So there's a level of comfort and assurance that comes from those things, but they don't make sense in every respect, Mr. Futrell. There has to be a case for them in terms of things which should be standardised as opposed to things which cannot be standardised. So you don't seek to impose a standard approach where it isn't prudent.
That's really what I want to focus on, if I could, which is the imposition. So this is the point of demarcation between responsibility, really. So, what role do you see the board of Burswood Limited playing in the determination of what aspects of the overall framework are implemented in Perth?
So there are a range of things which are, I want to use the word peculiar, but I don't mean that, different in every jurisdiction. They are peculiar to the jurisdiction. They are a function of state law. They are a function of the physical fabric of the service, the business, the context in which they operate. Each of those boards actually is responsible for the day-to-day running of their business. They have to be clear that the business that they oversight is being run consistent with all laws and not just the laws of the state or territory. They also have to be confident that it's operating consistent with its social licence. It's a good citizen in its local community. It's got the right, connections to groups. We have a big footprint in, for example, Aboriginal and Torres Strait Islander training, all those sorts of things. And each of those communities are different. How it does that in terms of discharging its responsibilities in respect of things which can, in terms of systems, be developed once, used often, can be, and to my mind properly should be, wherever possible, done in a collective sense. It doesn't abrogate their responsibility to sign off the implementation of those things.
So, just coming back to the question of imposition, then, is it the case then that you would foresee that the framework, in fact, is imposed, but the tailoring of it, and if you like, the application of it to the local party, would be within the boundaries of responsibility for Burswood Limited?
To the extent that tailoring is appropriate, Mr. Futrell, I mean, again, that's a judgment that has to be formed, and I find it hard to talk about that in a theoretical sense. But what I would say to you is one of the reasons why, if you look at subsidiaries, and this is a subsidiary of other companies, you have most often a connection between a person and very often the chair of the subsidiary then would sit on the parent company to ensure that if there are problems of the kind that you say in theory could be there, that those are identified and worked through. I mean, what I'd say to you, Mr. Futrell, in my experience of these things, is this is a question of goodwill. And if there is goodwill, you can find a way to manage these issues without actually, in a way, causing a material difficulty or a problem for directors in their duties in how they actually go about doing their jobs.
Thank you, Ms. Holden. Would that be convenient time?
Yes, it will. Ms. Halton, we usually take a break at this time of the day. It's 11:15. We'll come back at 11:30, which will be 2:30 your time.
Thank you.
All rise.
All right.
Halton, Mr. Futrell.
May it please the Commission. Ms Holton, could I ask that you find paragraph 47 of your statement, and you may have already touched on this today. I think you may have indicated you may have made a reference, I think, to Mr Carter's evidence on Friday, in the context of the composition of the Perth Limited Board. Can I just take you to a memo, which is CRW point 701.009.5375, and you may not recognise it because it's been redacted so heavily.
No, I do recognise it, Mr. Futrell.
And really there's two attachments to this memo. There's one which is the proposed or a draft charter. I take it you're familiar with that document?
Yes, I
am. And I just, you no doubt are aware that many other directives have been taken to this document, and in particular the proposed clause 4.1 on page 5381 and clause 5.1 on page 5383, which deals with the interaction between Burswood Limited and Crown Resorts, or the proposed interaction. So we got the wrong one. So we could navigate to 5.1 and show, yeah.
that's it. That's it now. Thank you.
Sorry. Now, can I just get your sense of, or your view as to whether you consider that whether you would consider that having a board, although the proposed charter does not identify a specific composition, it just requires there to be three and at least two, one to be a member of the Crown Resorts Board and one to be the CEO. Do you have a view about the extent to which the board of Burswood Limited should be increased in size, in other words, have a greater number of independent directors, that is to say, independent of both Crown Resorts Board and Crown Resorts Management?
So, Mr. Futrell, if I can make one observation about this drafting, and you're right, and the one you showed, I think the operator showed before, I mean, this is pretty standard in modern business governance, so I wouldn't see this as being extraordinary. And in respect of the drafting the minimum of three, because that is the legislative requirement, as you would know, we've had a conversation, and I think you may have already had evidence on this, but I'll give it to you in my words. We have had a conversation about potential additional WA-based director. One of the things that we're quite mindful of, and we took the same posture in relation to Melbourne, is that it's probably appropriate to hear the outcomes of respective royal commissions before we start adding people. And so that what we've got at the moment is the minimum which is needed, and I think it's got the right composition. This is pending, of course, Mr. Carter's approval for that particular role. So yes, there has been a conversation, not just about Perth in this respect, but also in relation to the other subsidiaries.
All right. Now, I'm just asking for your views rather than the conversations you've
Yeah, sure.
So, do you, do you consider, what is your view on the importance, if any, of appointing independent directors, I mean independent in both senses, to the board of Burswood Limited who have a connection to the local community in a direct way?
Yeah, I'm a big supporter of that, Mr. Futrell. We do have Marina Fuster as one of our board members, and she is, I think, probably, very connected to the temper and the tone of the local community, which I think is really important. But I do have a view that we do have to have a good connection to the local community. I think I said in answer to a couple of your earlier questions that all of the states and territories, I might have said it inter alia, it's all different. The context is different, the geography is different, the demographics in each of our communities that we serve are different. And so I do think a connection to WA is important in that respect.
All right, now can I just focus back a little on one of the questions I asked you before the break, which concerned the demarcation of responsibilities, and try and understand how that's proposed to be, or what the current state of proposals is, if you like. So if I could focus your attention on 5.1, the second paragraph there, which is directed to, this may have been what you said earlier, just before the break, about goodwill or something, words to that effect.
That's right.
The consultative, cooperative and in harmony with Crown Resorts aspect of that provision.
Yes. Look, Mr. Futrell, you actually do expect that sometimes on boards, and in fact, I wouldn't say it's what you go out to find in directors, you will have difference of views sometimes about what is best. That is actually a good approach, I think, sometimes, is to test each other on how to best find a way forward. But that is exactly what I was talking about earlier when I talked about finding ways to work through these things. Where I'm involved elsewhere, where there are subsidiaries, this is exactly the way these things operate, and I find it works very well. It doesn't mean that on the first blush everyone agrees with each other, but you work it through, and that's what a professional director does.
Okay, now that's, if you like, we might call it a soft provision as opposed to a harder provision. If you could ask you that you be shown pinpoint 5415, which is some amendments have been proposed to other aspects of the constitution of Burswood Limited. And if it just,
you'll have to blow that up, I'm sorry.
So if I could begin with 15.13, which is towards the bottom of the page, that's the first one. And this sort of harks back to something I asked you about earlier, which is where there's the potential for there to be conflicting interests between those of the subsidiaries and the parent company or holding company. And this effectively makes it clear that the subsidiary can act in the best interests of the holding company, and in so doing, the directors can feel relatively comfortable they won't be in breach of their directors' duties.
Well, except I would dispute that at one level, Mr. Futrell, because the reality of the state agreement is that the company is bound by that agreement. And we've had the conversation about whether, Burswood Limited should be a party or not. It feels, and in practice, I hope, will continue to behave consistently with that agreement, because that is its obligation. So what I'd say to you is that that obligation is very much something that the directors also have to be mindful of. They can't operate inconsistent with that particular provision.
All right. But in any event, insofar as the interests of the subsidiary are concerned, the provision has the effect of permitting the directors to act in the best interest, if you like, of the group, of the holding company.
And maybe that is in respect, and this is where I think we're traversing into places, Mr. Futrell, where not being a lawyer, I feel a little uncomfortable.
That's fine.
But my layperson's take on this would be that it does enable you to consider and adopt, by reference or otherwise, the use of shared resourcing, for example, because that is not only in your interest but in the interests of the group. But you still have your responsibilities as a director, which are not negated, I would have thought, and I would not interpret it as meaning this, but please, you're the lawyer, I'm not, tell me if I'm wrong, that it would not negate my responsibilities under the agreement.
All right, can I just, I don't want to, I will stray potentially into asking you for legal opinion, Ms. Holt.
Which I can't give you by definition.
I'll move off that topic onto the clause at 15.6, which is a little higher up on the page. If we could blow that one up. Now, this is clearly a work in progress, but
The whole, and Mr. Futrell, can I say the whole thing is a work in progress? You'll note that it's, I mean, this was something given to us by management as an idea. It hasn't been adopted, and we are mindful and respectful of the role of this Royal Commission.
okay, so, and this coming back to the a question I was asking you earlier about trying to put some definition around the demarcation of responsibilities.
Sure.
This appears to be at least an early attempt at so doing in a way that would reserve to the Crown Resorts Board effectively a power of veto on certain decision making. Has there been, or do you have a view about the kinds of powers or kinds of decisions that you would consider appropriate to be reserved to the Crown Resorts Board?
So there has not been any discussion of this. And when I give you an indication, these are not things that I've taken any advice on or have a fully and determined view on. But for obvious reasons, I would have thought they would include things which, for example, might include the selling or mortgaging of property. In other words, cutting across financing or other arrangements across the group. I would have thought anything which is a particular precedent that could potentially be problematic. Industrial agreements where you, I mean, say you came along and said, I'm going to give everyone a 20% pay rise, would strike me as being relevant there. I would think actually if the subsidiary board was about to take a decision that you believed was itself inconsistent with, for example, the agreement with the state or inconsistent with legislation in some way, you might want to keep that kind of power. I can't say that I've given this detailed thought, Mr. Futrell, but those are the things that spring to mind.
Okay, thank you. Now, a little before the break, you mentioned, I think, you asked some questions by Commissioner Finkelstein during the Victorian Royal Commission.
A lot. Which ones are we talking about, Mr. Futrell?
I'm going to try and... You may recall he asked you some questions during your examination around the perspective of the Victorian regulator wanting to have a degree of close oversight of the decision-making of the casino licensee in Victoria.
Yes.
Those are the questions he asked you. And he expressed a concern to you that if the decision-making were taken, his concern obviously in the context of the management agreement in Victoria and the head office provisions, etc., was that if the centralised decision-making was taken out of Melbourne, and presumably...
For the Melbourne casino?
Yes.
Yes.
Possibly unstated potential concern moved to Sydney, for example, that it could render the position of the regulator in Victoria impossible because it would lose that ability to have that close oversight on those who were making the decisions about how the casino would be operated. Now, and I've taken you to these provisions, having regard to the articles in the Constitution that deal with this requirement for the head office to be in Western Australia and the requirement to give notice and allow the regulator to attend meetings. What would you say to the proposition that if you centralise the operational, the decision making and the governance of Burswood Limited outside of Western Australia, you render it in a similar. You have a similar concern to that expressed by Commissioner Finkelstein, that it makes the regulator's role or function in overseeing the licensee somewhat difficult or possibly impossible.
Okay, can I take that in two chunks, if I might?
Yes.
The first of which is the hypothetical contention that if you're a regulator that's located in one place, you can't do your job regulating in different jurisdictions. That's manifestly not the case, because we have, for example, the National Trucking Regulator lives in Brisbane. So apart from the fact I don't agree with the contention that a regulator, if they're located in one place, can't regulate across other parts of the country, but in this particular case, I don't support the running or the management of Burswood anywhere other than Burswood. And I need to be clear about that, Mr. Futrell. We've talked about what functions might be properly adopted by, for example, the Burswood board, using the shared resources of the group. And that's appropriate. I draw the parallel, if you'll just indulge me, with, you don't expect that somebody in St George's Terrace is going to have written the computer program that drives your mobile phone. You just adopt it. Now, an IT system, most of us actually buy bog standard software and we just use it regardless of where we are, not just actually in Australia, but around the world. And we can have a view about whether, it always does what we want, but that's a separate question, right? But what I'd say to you is my understanding, and this is consistent with what Mr. Carter said, I think, to you on Friday, and it's absolutely consistent with my view, is that the Burswood board should run the business. Now, the fact that they may adopt particular things, they have and the management in Burswood has the capacity to participate in these shared resources, I don't think is antithetical to the running of the business and indeed the operation of the regulator. Because the regulator should be able and would be able, in the way that I've described this to you, to actually see that process of decision making, to have a view. As you rightly say, they are absolutely empowered, and it looks to me like there's been a dropping of the ball on making sure that they're properly invited to all of those meetings. But they should be able to see all that decision making. I mean, that is consistent with my understanding and certainly the understanding of Mr. Carter about how this should operate.
All right. If, however, certain decisions are reserved to the Crown Resorts Board, that level of visibility on decision making would be lost to that extent.
Well, look, again, I'm not the lawyer here. And it strikes me, if there is a decision which is material to the operation of Burswood, it strikes me that regulator, much as, I'm not a director of Burswood, and here I am giving evidence in front of you as a Royal Commission, I'm not aware of a limitation on the ability of your regulator to actually seek input and scrutiny of decisions that might affect Burswood, but perhaps you understand more about the detail of that regime than I do, Mr. Futrell.
Okay, so is it effectively your view then that is your view effectively that as a matter of practice, Burswood Limited is in fact the central management and control of it is in fact in Western Australia in any event.
I think it is. That is actually my understanding. Now, I think we could have a conversation, and I'm not privy to all of the historical operations of Burswood Limited. But what I point you to, again, is Mr. Carter's, and I think we would all acknowledge he's very experienced, and I think he's very genuine in the view he takes about how he's going to run that board. And I will be fully supportive of him doing that.
All right. Now, I think Commissioner Finkelstein also asked you similar questions to me around the concern he had about the potential for there to be conflicting interests between Crown Melbourne and Crown Resorts more broadly.
I don't recall those specific questions. I thought he asked me a bit about Sydney, but to be honest with you, there were a lot of questions, so you may well be right. I haven't got a transcript in front of me.
What he put to you, I'm paraphrasing it, was that and you may have already answered this, Holden, that he expressed the view that the Crown Melbourne operation should be fully responsible for oversight of all of the operations in Melbourne. And the same could be said about Burswood Limited. So do I understand from your the earlier passage of or early exchanges with me that you consider that to be effectively the case?
Well, what I understand it to be is that local management and the board are responsible for what happens on their patch. Now, we aggregate a view, so take AML, we have to aggregate a view across all of our properties to form a view about, for example, whether our systems are effective, efficient, do as they must. So if you look at how you might form a view about whether we're meeting our legal obligations in that respect, we will form a view across the corporation. These are subsidiaries. They're not standalone companies, but they are subsidiaries. They're not part of the one company. And that's the distinction I think we're talking about here.
Okay. Now, I don't expect you to have read all of the report that has been published in as a consequence of the Victorian Royal Commission.
Yeah.
I expect you've probably familiarised yourself with the recommendations.
Yes, I have. But you're right, 600 and something odd pages. I can't pass the exam on what's on page 463 at paragraph 3.
Well, you'll be pleased to know I'm not going to examine you on every part of it.
Thank you.
But I am interested in your views on a couple of the recommendations.
Yes, certainly.
And this is in keeping with the same theory we're on, really. And the I'm just going to find recommendation 29. Get it right. The recommendation 29 was that the Casino Control Act be amended to impose an obligation on the casino operator to have a majority of its board as independent directors, including independent of any ultimate or intermediate holding company. Mm-hmm. We have traversed this ground a little. Your responses to my questions earlier were really, I think, directed to if you like, the benefits associated with the current status quo. This is more a policy question. Do you have a view on whether, as a matter of policy, it would be in the interests of the Western Australian government to amend the Casino Act here, Casino Control Act here, to include a similar provision?
I struggle with how that would work in the context of something that's a subsidiary. And elsewhere, where I've seen subsidiaries subject not just to different Commonwealth state jurisdictions, but to different country jurisdictions, subsidiaries in that context have, the particular one I'm thinking of as I say this, has 50% independent directors and 50% who are part of or connected to the parent. And I think that works well. But where there is, and particularly if there is an absence of a Section 187 of the Corps Act provision in that charter and in the Constitution, I struggle to see how you reconcile those things. Now, I'm not aware, there may be examples, Mr. Future, elsewhere in corporate governance. And if I were giving policy advice on this, which I'm not, but I would want to find some examples of where that has worked and how it has worked to the benefit of the jurisdiction and to the overall corporation, because I have not seen an example, and there might be one, but I'm not aware of it.
So, in response, your response really is in two parts, as I take it, Ms. Holder. One is there's a practical effect of imposing a condition of that nature on a company, a licensee that happens to be a subsidiary.
Yep.
Which is really the perspective, if you like, of the holding company or the subsidiary, not so much the position of the regulator or the government.
Yes, that's true.
The second aspect of your answer, though, it seems to me that you don't have a view on the policy because you take the view you'd need to know more about potential benefits that would be driven would flow. Is that the?
No, I would say I am more sceptical than that. I have a passing familiarity with corporate governance in a whole range of areas. I know what I've seen works. I have not seen this, and I have not seen this work, and therefore I would start I wouldn't start with a closed mind, Mr. Futrell, but I would really want to be convinced, and I would worry that you would end up in a position where you would make the notion. How you'd manage harmonious governance in that context, I'm not entirely certain. But as with all these are policy questions, to your point, and you'd have to work your way through it. But I start not being convinced it's going to be the right answer. And as I've said, I've seen it work with 50-50, and that has worked well, but majority I worry about.
Okay, and I'm going to ask you a similar series of questions relating to recommendation 30, which was directed to the management structure. And there's a recommendation that the Casino Control Act in Victoria be amended to so that the casino operator is not permitted to delegate any of its functions to any person or body of persons other than a subcommittee of the board or an individual director, that is to say, of the licensee company.
Yep.
And the operator must appoint effectively a full-time group of managers, CEO, CFO, Chief Operating Officer, and various other heads of departments that report to and take instructions from the casino operator and the casino operator alone.
Mm-hmm.
Do you have a view about whether introduction of a similar provisions of a similar nature in Western Australia would be to the advantage of the state of Western Australia?
I would have concerns it would not be to the advantage of Western Australia, but I caveat that, Mr. Futrell, by saying I don't fully understand yet what that recommendation means. And it is fair to say that the Victorian government has already introduced legislation in respect of its top priorities in terms of the recommendations. And you will note that that means the large majority of the recommendations they have not introduced legislation in respect of, and they've indicated there'll be a period of consultation. So my expectation is trying to work through what some of these actually mean will be one of the things that has to occur. But again, that it sounds on the face of it to me like a completely freestanding business, or it could on one reading mean that, and I think that's potentially quite problematic.
And problematic in the context of being a subsidiary of a group? Is that
Well, probably both being a subsidiary, but also in terms of, and this is why I'm saying, and I think we're kind of speculating here, Mr. Futrell, which I'm a bit loath to do. But if you had to build all of the systems for AML CTF just for each of our services, that is really quite problematic. It's exactly the same as the argument and the way I draw a parallel between not having the software on each of your mobile phones developed somewhere on St George's Terrace. There are economies, but also benefits, significant benefits in terms of quality, etc., that come from centralising that kind of process of building, if I can put it in that sense. So I would worry about that.
all right? I don't need to get into debate with you about whether you can do it without. In other words, you can centralise process without centralising the decision making.
And we're into splitting a level of hair here. So I agree with you that there's a whole series of conversations that had to be had about that issue. But what I can say to you is I don't fully understand what that recommendation means yet, and I fully expect that we will be having exactly that dialogue with the Victorian government.
Okay, thank you, Ms Holton. Now, I think I suspect I know what your answers are going to be to these questions, but because of the way you've answered a number of my earlier questions, and it may be you've effectively dealt with these, but I just want to make sure that they're covered. Now, I want to understand a little more, if I may, about what you conceive of, the idea of the director's duty to act in the best interests of the company, and what facets or components do you consider, what interests in your view are taken into account in that conception?
Well, I take it to having a fairly broad meaning, to be honest with you. There's the sort of strict legal issues in respect of, the role you have as a director in effectively protecting the shareholders' interest. But you do that through a variety of means, and that includes the good order and good governance of the company. That includes its obligations, widely drawn to include its regulatory obligations, its social licence, its standing, and it is a broader sense than just the straight drive for profit. Shareholder value has a broader meaning than that. And I think, as I said, certainly in one of my statements, you cannot deliver shareholder value unless you are consistent and compliant with your social licence. So that's how I conceive of it.
You mentioned social licence a couple of times, in fact, and you mentioned it also earlier, and it's a phrase that may have different meanings to different people. So, what do you put in the bucket of social licence?
What I'd say on social licence is it has a broader meaning, I think, in most people's head than just a kind of de minimis sense of regulatory compliance. I mean, and I do think community standards on this have changed. The community is much more aware of the role that corporations play in the fabric of our social life, not just in our economy. So they have a sense of who we are as employers, whether we're good citizens, whether we actually are good members of the community, whether we contribute more broadly than just running our commercial operations and then kind of going home at the end of the day and making no other contribution. The truth is, particularly in this industry where we have a licence which is a privilege, and the privilege is granted by governments because essentially the people give them the right to so do, and And ultimately, if the people don't approve of how we operate, ultimately that will reverberate. So social license has this much broader connotation, I think, of are we good citizens? Do we do the right thing? Are we good, upstanding members of the community? As opposed to that kind of narrow black letter view of have we ticked the boxes on regulatory compliance? That's how I see it.
All right. And can I just explore that a little bit more? You've mentioned in this industry, obviously you're referring there to the casino gaming industry, and you've mentioned the aspect of privilege associated with having a casino license.
Yes. Yeah.
In that framework, and I think you've said a couple of times that it's more than just strict compliance with your regulatory obligations. In taking those things all together and putting them into the context of a Western Australian casino operator,
Yep.
what aspects of something more than compliance with the regulatory framework do you have in mind?
In WA in particular?
Well, it probably doesn't. It probably covers all states, but I'm interested, obviously, from this Commission's perspective in Western.
Yes, sure. So the issue here is, what do we do to give back to the community? How do we be a good citizen in the community? What do we do in terms of being part of the social fabric of the community? Now, Burswood is iconic in Perth in terms of where it sits. I mean, I remember going past the Burswood site in the early 1970s. In fact, the first place I ever arrived in Australia was Perth, and I drove past that Burswood site. It was one of the first things I ever saw of Australian soil. And it has blossomed and grown since what was, a relatively uninteresting piece of land to something which is a focal point. So being part of the community, everything from telethon to being a host of various events that the community regards as being very important. WA is a big sporting state, as I think the rest of the country would acknowledge. More AFL teams per head than most other states could withstand, with the exception of Victoria. Being a good citizen in terms of ensuring, for example, that we take seriously employment issues, particularly for people who would not necessarily feature in other employers' work. Crown College, the work we do with Aboriginal and Torres Strait Islander peoples, issues in respect of working with, the charitable sector, et cetera, et cetera. So in the pandemic, and in fact, I think I said this in the last of the notes I sent out to staff, the fact that people from our workplace have gone out and done voluntary work supporting people who are really struggling in lockdowns. Now, you've only had very intermittent lockdowns, but people in the WA, in our employment in WA, have done those things as well. So it's those sort of things. I could probably come up with more examples, but it's basically being a good citizen and participating in the community, which in every community does look a little bit different depending on the makeup of that community.
Can I ask you a couple of things that are obviously of interest to this Commission in that context? And one is, plainly, there's if you take the AML and CTF framework as an example, there's a compliance aspect with the strict letter of the AML CTF Act.
Yeah.
Legally. Do you see any role in the social licence bucket for a casino operator to take active steps to prevent the infiltration of its operations by criminal elements?
Yeah, so one of the things that's really important in this context is not just the reactive component, it's the preventative component. And you haven't seen Steve Blackburn yet, but when you do, he can talk to you in quite a level of detail about that preventative component. I would also say that we have been taking, and I'm very pleased about this, much more sort of deliberate steps, which I think were necessary, and they absolutely are necessary, to take a preventative rather than a reactive approach, even to the individuals who come into our facilities. So absent absolute confidence about who someone is and where their source of wealth is, for example, their bona fides, if I can put it in that way. If people haven't wanted, for privacy reasons, to tell us what their source of wealth is, we won't deal with them. So that preventative component is definitely part of our role. We have under negotiation, we already have an agreement with WAPOL, which is in the process of being renegotiated, is my understanding. But we're also in the process of getting those agreements in place in a number of other states. We've had good working relationships, but we want formal agreements with the police forces in other places. Similarly with the National Criminal Intelligence Commission, similarly with others with whom we have shared information, and you'll appreciate that there's some materials that we're not enabled to talk about in that respect, but actually being an active part of that world. It's also consistent in terms of the preventative component. The work that we've done, there is, and I won't get the name right, so I apologise. There is a group of industry players who come together to talk about the operation of the casino industry. There is a proposal to actually have a national banning register for people. There have been issues in terms of the privacy provisions across the individual states and territories. It looks, as best I can tell, that some of those issues are being resolved, and that would enable us to implement that kind of arrangement. So yes, we shouldn't be reactive. We should also indulge in prevention.
And can I ask you whether your view relating to reaction versus prevention extends to the area of harm minimisation as well?
So harm minimisation, yes, we should. The challenge, and no doubt we'll talk about this in some respects, the challenge will be to identify, and we've done work on this, what the predictive tools are in respect of people at risk of harm. Talking to Professor Blazinski, and based on my own knowledge, we know that most of the people who gamble do so safely and without or with limited risk of harm. But there is a small group of people for whom there is the potential or the reality of harm. And and I'm sure you have looked at it, if you look at the work of the panel, and particularly the public health approach that's contained in that panel, in their report, you might remember it as the diagram that's got the different arrows on it. What it demonstrates is that you do need to take different approaches, and the work that we've been doing, looking to see whether we can come up with much more predictive models of where harm is likely in order to enable us to intervene, is part of the research agenda that we have. The caveat, Mr. Futrell, I would like to put on this is I actually think for people who come to the casino, they have more chance, and increasingly more chance, of having access to people who can intervene and provide them with assistance and referral than if they're sitting in their lounge room at 3 a.m. On internet gaming sites where there is no one to intervene. And I do think, so we have to think about what we do in harm minimisation in the broader framework and in consultation with people who themselves are expert. And by that, I'm not just talking about academics. I'm also talking about community sector people who deal with the people, the problems that do eventuate. But yeah, we absolutely have a role.
And that focus on prevention, is that a more recent focus of the Crown Resorts Board?
No, I wouldn't say so, actually. What I'd say to you is the conversation about prevention was certainly occurring. So you'd remember that the 6th review, I think its final report was, I want to say June 2018. The conversation about prevention and best practice was certainly a conversation I know Professor Woolvarth was having with that committee, remembering I wasn't a member, but he and I were talking about it. And in the proposal that came forward to actually get agreement to establish the panel, which from memory was established in early 2019. It could have been the end of 2018. Don't hold me to exactly when it was. But the notion of prevention was very much part of that discussion. Now, sadly, we all know that much of what we were doing got disrupted by COVID. But there was definitely a conversation about that, and that was one of the emphases, obviously, and I referred you to the kind of squiggly line diagram in their report. That is one of the emphasis there as well.
What about in the area of financial crime?
So financial crime, I would say that there was discussion, and there's a distinction I want to make here between, and I've already made this point, there was probably less conversation about this at the group board because of where the responsibility under the AML-CTF Act sat. So there was more of a compliance function. So I can't say in those early days that there was particular discussion about financial crime other than in the board, not in the specific.
Okay, and has there been a more recent change in that area?
Well, certainly, and as I said, you'll talk with Mr. Blackburn. I certainly was, I think, particularly focused on these issues given a number of events and asked a series of questions about these matters. And one of the reasons for the board agreeing, and I'd have to be reminded quite when it was, but there was an explicit decision to actually recruit a specific position, which for the group and then the subsidiaries would have this very much as a focus, and that, of course, is where Mr. Blackburn's recruitment came from.
Okay, and was that decision made before or after the Bergen report was published?
Before.
Okay, can I ask you some? I know you've already dealt with the remediation plan earlier today, but I want to come back to that and ask you some questions about it. Areas that are maybe some of which you've got more specific interest in or knowledge of. But before I do that, can I ask whether there's any? And I know it's a large document. It's got many items in it. Are there any of the items that you see as being of particular addressing particular issues or acute issues that you think need to be dealt with more rapidly or more comprehensively than others?
Yeah. It's a bit like asking whether I have a favourite child, isn't it? So, yours, you say that they're all really important because they are. What I'd say to you is the ones that are most acute there's two, can I describe them as two buckets in terms of acute level of importance? The first of which is the regulatory compliance piece. And that comprehends, obviously, the AML-CTF. It comprehends issues, I think, in the risk bucket as well. We've made some good progress about risk, but there's more to do. And then the other bucket, I think, is the culture piece. And the reason I call the two domains out is you can't, to my mind, sustain what you need to do in the first bucket unless you have proactively addressed the culture piece. And I'm particularly conscious of that, having been a CEO and run very large organisations and understanding exactly how important culture is. But secondly, going through in the banking context, the issues out of the Royal Commission into banking and the sustained focus on culture as part of implementation of a number of the issues that came out in that context. So to my mind, the two, they're kind of the most important domains, if that makes sense. And I've been particularly focused on the AML-CTF work in the shorter term because we brought in somebody very explicitly to raise that work. But, they're all important, Mr. Futrell.
All right. Do I detect from that answer that you think a focus on culture is of some significance to bring about, or giving it, if you like, lasting change?
Absolutely. And again, if you think about my academic background and my interest, I mean, it's probably not a surprise I would say that to you. Essentially, and the way I describe this, and you'll pardon me if I use the kind of colloquial, when you run an organisation with 20 people in it, you can probably sit on their shoulder for every significant decision they take. When you're running an organisation of 20,000 people, you have not got a hope of doing that. So if you don't have all of the levers and drivers running in congruence, then you have to have measurement, and you have to have all sorts of systems to ensure that you can measure and monitor. But it is much easier to implement, to drive that kind of approach if your culture sees it and basically lives and breathes it as being one of the fundamental tenets of who you are and how you operate. So the culture piece, I think, and I think no doubt we'll talk about it, the Deloitte report has been really terrific, because what it does is it looks at the connection between the drivers and sometimes the impediments to actually delivering on all of those things that we think are important. So yes, sorry, Mr. Futrell, long way of saying yes, it's extremely important.
Okay. I do want to come back to deal with the culture piece in more detail, obviously, but thank you for that answer. So just, and I appreciate there's quite a bit of material in the remediation plan. Do you have any concerns though about its adequacy?
No, but what I'd say to you is it's a changing document. It's responsive to, as we go along, what we discover. We've got these broad domains. It is very wide-ranging, as you have acknowledged. It is, however, a living document, and that sounds like a horrible description, but it has to be responsive. You do something, you try something, you learn from it, and then you adjust. So I don't have concerns that the mechanism that is the remediation plan and all of its surrounds isn't adequate. I would be concerned if I wasn't seeing the continual enhancement, improvement, learning from experience, getting more advice, and then the flexibility that we're seeing around that. And I would use, as an example, working in New South Wales with Kroll, as you know, the monitor, which is proving a very good process where they test, we develop, we talk. And so it's a very big job, Mr. Futrell, but I'm quite optimistic that it will do what it needs to do. Although, you know, the report in terms of the where we're at the end of November will no doubt look different to the report at the end of October.
And given the, it is quite an ambitious program, do you have any concerns about the scope?
No, I don't. I think the scope, I think I've already indicated there's some stuff that probably isn't actually inside the scope that's congruent with this. I think these are the things that we absolutely have to focus on. I think there will be specific issues, and this is where we go back to not quite where we started, but the recent discussion we had about the context in each state and territory. Because, you know, we know industrial agreements are different, and we know the demographic of our staff are different, and we have to make sure that we're communicating effectively in each of those places. We're talking our management is talking to people, the board members are talking to people in each of those places. But no, I'm not worried that it's missing something major, and I'm not worried that there isn't an absolute commitment to the change that's necessary.
Now, you've mentioned Mr. McCann, I think, Mr. Blackburn and Mr. Weeks times so far today. Do you have any concerns about whether you've got enough people and the right people in place to deliver the program?
Look, we still, and in fact, I was only talking to Mr. McCann about this issue over the weekend. There are, I think, a number of areas where we will look to enhance the skills that we need. I think that's inevitable as we go through this process. There are some holes in our senior management team. So we don't currently have a CEO of Sydney, for example. That's a really crucial role, getting someone who's the right fit. So my expectation is that we will see additional people added to the roster. And in fact, I was talking with one of our newer people in the risk area just recently about the work that's going on there. So I think we will continue to enhance. I'm not saying that we're going to add 100% of that again, Mr. Futrell, but I think as needed, we will add capability, yes.
Is there anyone in view at the moment for another senior position in the management structure?
Well, I've already indicated we do need someone to run Sydney, so that is definitely a position that we are searching for.
But no one in view, just at the moment?
No, someone in view.
Right, okay. And other than that, are you, at the senior level, are you confident, do you have confidence that those people in the positions that they're in will deliver on the remediation plan?
I have no doubt about that, Mr. Futrell. I mean, these people, I personally was involved in the selection of Mr. Blackburn because I wanted to be absolutely confident that we got the right skills and experience. The former chairman, former executive chairman, and Ms. Korsanos and I took a personal hand in the recruitment of a number of these senior executives, particularly in the period at the beginning of this year when it was all hands to the pump. The people we've recruited, I am very confident. These are people with very significant business careers. They are people who've worked in companies, have really significant, have significant experience. A new general counsel, Betty Ivanoff, was the general counsel of Coca-Cola Amatil before she joined us. I mean, these are very experienced, seasoned professionals. So I have confidence in them as a team. Yes, I do.
Okay, can I ask you some questions about an area that you presume you have some specific knowledge of, which is the risk management part of the remediation program?
Yes.
And I might just take you to the remediation plan that I have, which is a document that was delivered at the end of September.
Yep.
Just CRW.701.006.4272.
Yep, it's on the screen. Thank you.
And we want to go to page pinpoint 4319, which is where the risk management section commences. And there are a number of items. There's items 26, 27, there's a number of pages.
Yeah.
As I read through these, I noticed that responsibility is largely with Ms. Seegers, and I think in nearly every respect it's indicating complete.
Yeah, and as I said to you, I mean, I think what you'll find is there's more being done on risk management. This is a conversation I've had.
Bolton.
Sorry.
There's some material on this plan that appears to call for an NPO, or certainly an application for an NPO. in respect of certain procedures that might reveal how things are to be tackled.
All right, we'll have this document only on the in-room screens, please.
Sorry for the interruption.
No problem. It was quite alarming when the camera started moving. I thought, what's happened?
No, I just finished making the observation that
It says complete, yeah.
yeah, and
Yeah.
you began to explain something about that.
Yes, absolutely. So there's further work going on in respect of the risk management changes. And I mentioned, I think earlier, that I have been speaking recently with another new recruit, or someone who's come in to assist with the uplift on risk. I mean, as I think has been probably well canvassed elsewhere, and I suspect you know, and therefore I won't repeat, there's been quite a period of uplift in terms of policies, structures, et cetera, around risk. The thing that we are moving to do is to absolutely cement into place issues around, if I can put it this way, how we make sure that the implementation is successful and sustainable. So what we're looking to do, and I'm hoping to get this for the next risk management committee, which is on, I think, the 17th of November, but please don't hold me to that. What we've got to do is continue, and I think I said this to Commissioner Finkelstein, and I think I probably said it in my witness statements, that we're continuing the work on risk management. So we've got to do further work on uplift, particularly in relation to improving the second line processes. You're familiar, I've no doubt, with the 3 lines of defence and how we talk about that implementation. We've got to be confident about the assurance around these matters. There's a lot of work going on, obviously, in the AML CTF area here. And we've got, the way I would think of this, Mr. Futrell, is how do we allocate risk to owners? Who owns a risk? How do we do things like have triggers? Now, we have the ERCCs as mechanisms for reporting. We have CURA, which is the survey for reporting. But how do we institutionalise through the sort of development of these triggers what is, for example, a board reportable event? How do you escalate in a way that, again, we have assurance about? So there's a lot that's happened, which is why some of these things are complete. You would again be aware, and I think you might be calling him, Mr. Deans did a report for Commissioner Finkelstein. We're in the process of implementing all of his very helpful recommendations, and I think I'm right. Are you calling him? Am I right in thinking that?
We've got a report from him.
Oh, okay. Because one of the things I want to do, and we agreed some time ago to do, was to invite him to come and talk with us. But I didn't want to actually do that until I was confident. I didn't want to give him any kind of conflict. If that makes sense. So I want to get him to come to talk with both the risk committee and, if the board are interested, the board as well, just in terms of his observations. So there's a lot to do here, and you're never finished with risk, Mr. Futrell. I mean, the thing I'd say to you about every company is, if you go back 20 years, no one even knew what the term risk was, and it's been an evolving area of practice. We're getting much better, I think, at knowing what it is, how to manage it, etc. But a bit like the culture piece, this work really started in 2018. There were some structures that had the name of risk and some processes there. But I think, as I said, I haven't gone back and refreshed my memory, a lot of what occurred prior to that was probably not consistent with certainly a modern framework. So there's a lot still going on here. So notwithstanding what this document might say, and I think I did talk about things in the periphery to these processes, there's a lot going on risk.
Okay. Perhaps you've obviously covered a fair bit of territory with that answer, so
Sorry.
I might want to just focus on a few of those areas that you've.
Sure.
Can I ask if you can find your statement to this commission, which is the one that starts CRW 998-002-0897, and just direct your attention to paragraph 20, where this is where I think you've picked up, and I understand to be, in effect, adopting what you said, or the statement you gave to the Victorian Royal Commission, largely in terms of describing what the risk management framework and structures and policies are
Yes.
present, and in some respects you deal with the past and changes that have taken place in response to questions that Commissioner Finkelstein asked of you. And then this really was my area of interest. There's references in paragraph 21 to the Kroll engagement with Kroll, and Kroll's produced a draft report. No doubt you're familiar with that document.
I haven't seen the Kroll report itself, no.
Okay. Are you familiar with the extent to which Kroll has been providing feedback to Crown Resorts about its progress against the ILGA program?
In the abstract, not in the specific. Okay. So I haven't been given that Kroll report, and frankly, I'm not sure that I should expect to be given that. I'm being given those higher level reports about where we're at in our relationship with Kroll and progress, but I have not been given the Kroll report.
All right. I think you've referred, however, to a memorandum you received from Ms. Seegers in your statement, which is CRW.701.009.3889.
Yes.
And there's one area I would like to sort of understand where you're up to. You may recall that one of the recommendations that Mr. Deans made in his report to the Victorian Royal Commission was that the risk appetite statement be a separate risk appetite statement be prepared.
Yep.
Prepared in a way that gave some granular detail around the or explanation for the risk, and there's a reference on page 0.3892 in Ms. Seegers' memo to that.
Which I don't know what that is. I'm sorry, Mr. Futrell. Can you show it to me? If you're going to refer to it in detail, probably will be helpful.
So you should have it on the screen in front of you. It's item 17 under risk management framework. Just scroll down, please, so you could get the full item there. Yep. I think it's
item 17. Is that the one?
I think it's paraphrasing there, or perhaps even.
Yeah, that's the one. I remember. Yeah, thank you.
Now, it's indicated that's underway.
That's right.
I think it may have been in the course of your evidence in the Bergen inquiry, I think you yourself made this point about the risk appetite statement having some deficiencies in that it didn't provide sufficient granularity or detail around the risks and the triggers.
Mm-hmm.
And that was in, I think, October last year or thereabouts. Mm-hmm. So the question really is, it's been underway, or should have been underway for some time. What stage are we at, and where would we like to see something more concrete?
Yeah, thank you. Well, two things, if I might. Firstly, there were a series of changes made following that particular. So if I go back to the Bergen context, there were more specific changes made to the risk appetite, and that was certainly one of the steps. I think what I was saying to you before about the work that is currently underway goes at least in good part to this. So there has been ongoing updating of the risk appetite. So the risk appetite that was the case in 2020 is not the same as the risk appetite in 2021. Mr. Deans, in his report for Finkelstein, goes through the explicit statement in respect of the risk appetite, and that's where he goes further and says these things, we ought to disaggregate this. So that comes from the Dean's report, and this has always been the intention. But whilst, as I think I indicated to you, we've been on a journey, ghastly management speak, but we have been on a journey. So we've been taking this in steps. And this next phase, and I think I indicated to you, I haven't seen yet what I'm going to get for the risk committee on the 17th of November and where they're up to in the work on this particular component as part of the uplift. I don't yet know, but I'm hoping that the risk uplift plan, if it doesn't make proposals about this, and this is still quite a lot of work to do because you have to work through with each of the businesses, and particularly this issue about ownership. So my expectation is we're going to see the process to do this. And this is one of the reasons I actually would quite like to talk with Mr. Deans, because he has a lot of experience of this, albeit in banking. I have experience in banking. Mr. Carter has experience in banking. So it is underway, is my understanding, but quite where it is at, I can't answer that in the specific, other than to say it's a priority.
Okay. Can I ask you to turn up your statement to the Bergen inquiry, because this might assist us to understand what's meant by granularity actually.
Yes.
So this is CRW.998.001.0152, and if we could go to pinpoint 0160 in paragraph 74. Vic, it's a Vic RC one. Yep, that's it.
Yeah.
And you're obviously extracted from the board the way that risk is reported to the RMC.
Yes.
Figure 4.
Yes.
And it might need to blow it up because it's a bit hard to read in its current form. Is that what is that a sort of an example of what one might understand to be a statement with a bit more granularity to the information? So you've got
No. So this is part of the metrics, Mr. Futrell. I mean, essentially, this is one of the reasons I want to talk to Mr. Deans, to be absolutely clear about whether what he's talking about, what I'm talking about, what other people are talking about are all the same thing. So if you think about it, you will have a series of triggers and measures that will give you a sense of whether you're inside appetite, outside appetite, if there's something you should be focused on. Your appetite, as I understand what he was saying, actually can be disaggregated below the macro appetite you have as a business into key areas. So we know, for example, and again, you can talk with Mr. Blackburn about this because he'll be far more eloquent than I can be, about the risk appetite in respect of AML. And you will already see in that area, we have enunciated a risk appetite in respect of AML. So what you've got your macro appetite as expressed. And in fact, I think Commissioner Finkelstein quotes that appetite as it existed, which we talk with him about. But what we've got now explicitly and at a more granular level is a specific appetite, for example, in respect of AML. So the question about which other areas you need an appetite expressed in respect of, and then how that cascades down in respect of measures and triggers is the conversation. So what we've got here, we've got a framework and we've got these sorts of measures. But I think, and what I mean when I say this is there are specific domains where we need a specific statement of appetite in those areas. And then we will have the specific triggers and the measures. So these are across the whole business, but I would expect them to be supplemented through this work.
Okay, so when you say these are across the whole business, are you now referring to the figure 4 in your statement?
Correct. That's right. Because they're a dashboard, it's an indicator dashboard, whereas what he was talking about, I believe, to be a statement of appetite. And one of the things you do is you express your appetite in respect of risk, which we have for the whole business. But as I understand his meaning, it's what is your appetite in a number of subsidiary areas. And by that, I'm not just talking about Perth, Sydney, Melbourne. I'm talking about AML, and it might well be in hospitality. It might well be, again, this is the thing, this is the work. And then the issue about who owns the risk, because normally speaking, you would have somebody who owns a particular risk. I think we all probably would know that Mr. Blackburn is likely to be the risk owner on AML, but with these other risks, who owns them?
And do you know that now, or is it something to be part of the future?
No, it's something, yes. So I think there are bits of the business where they kind of all own the risk in their bit of the business. But what you would have, to my mind, and for good practice, is you would have as part of your responsibilities, and again, we've seen this in banking. So if you think about the BEAR regime, which will be the FAR regime fairly soon, and and this is something I've been talking about for quite a long time, being very clear about who is the risk owner. And then there are accountabilities that attract to the person who is the risk owner, which cascade into, are they properly trained? Are they held properly accountable? What does their remuneration arrangement do in terms of ensuring that all of the arrangements in respect of that individual align and they are held accountable in respect of that risk?
Okay, so that's the work in progress, that's the future. What do we make of the present, which is this figure 4?
Yep.
It appears to, if you look at the categories in the first column, they correlate, broadly speaking, to the various categories of risk
Yes.
that are identified in the risk matrix.
Yes.
And then there are some specific key indicators that are identified in the centre of the page.
Yes.
There's a frequency, which is self-explanatory, then there's a budget, target, average, which that appears to be a metric of some kind that you're measuring in respect of each risk.
That's right.
And then there's a trend, which essentially is a traffic light saying, are we good? Are we on trend, or are we off outside the boundaries of our metric? Correct. So in the concept of risk appetite language, is that where you see a red? Is that describing a situation where you're outside your appetite?
Not necessarily. It's something to be attended to, and that is exactly the work that I was talking about, Mr. Futrell. So what you would normally do is you would say, what are the triggers? And not everything is amenable to a number in terms of whether you're inside or whether you're outside appetite. But what you have is a series of triggers, and this is the point about escalation. And when I talked earlier about you want several means of actually being alerted to issues in respect of risk. You want some of these things to be systematised, data-driven, and therefore the triggers mean that they are automatically brought forward to whichever is the governance level that's relevant. And the question of what those triggers are, that work is underway. So this doesn't mean outside appetite. This means there's a trend or something here which is possibly problematic. It does not signal inside or outside appetite. That is the work that's underway.
I see. So you, as the chair of the RMC receiving this in any given month, are given some indication of where you should perhaps be asking questions by reference to whether it's red, amber or green. Is that the gist of it?
Yeah, I think that's right. But what I'd say, again, this is my point. What you want is a much more, and this is, again, I'm using this word, it may mean different things to different people. You may want a much more granular, I want a much more granular approach, which actually by definition alerts me whether I'm inside or on the edge of or uncomfortable in respect of or potentially outside appetite. As I've said, not everything is reducible to a number, because not operating consistent with your social license, I think is probably hard to distill into numbers. But the combination of things may well say to you, actually, we're not in a good place. So you have to have both of these elements. You have to have the judgment component, but also you really do want, and it's exactly the same as AML, you want a really, a system which automatically generates information which is aggregated up, which draws to your attention if you don't happen to see it. I mean, when I was talking to the person who's actually doing this current piece of work, I actually said to her, as a CEO, when I was doing these things as a CEO, I had a lot of metrics in front of me, but I also needed to be able to smell it if there was something wrong. And this is the same. There's some things which aren't reducible to numbers, but you know, or you should know, based on your understanding of the business. So this has to have both elements to it.
All right. So just staying, if I could, with the current information you're receiving at the RMC level.
Yep.
This is an aggregated dashboard, isn't it? This is covering all businesses.
That's right.
Which in today's terms means Crown Melbourne and Crown Perth, or possibly Fair and all the others as well.
All of them, yeah, that's exactly right. And what I would expect, Mr. Futrell, is that you would get, I mean, a bit like we did with the culture survey, we actually could look at the different properties as well as look at the group as a whole. You would have seen that in the Deloitte report, that it was disaggregated, assuming you saw that version, but there was a version that gave you the differences across the properties. You would actually expect to see this in time, so the Perth board can have that look at what they are seeing in their context.
Yes, that was going to be my question, because I haven't seen this kind of dashboard in the board papers for Burswood Limited.
No, and one of the things, and you would appreciate with my history, Mr. Futrell, one of the things I've got a lot of experience of is ensuring that I engage the states and territories in things. One of the things I want to be confident of is that each of the subsidiary boards has a look at the work that is done in this area, because it has to be fit for purpose for each of those boards. So if there are particular things of interest or concern, or peculiar, that word again, to the subsidiaries, they have to be taken account of, and that means that the directors in each of those places have the same access to this metrics-driven warning system that you have at a group level.
And so how, as I, maybe I've missed it, Ms. Holder, but I couldn't find any of the various framework, policy, charters, any reference to this key indicator document. How did this come into existence, and who chose the metrics?
So it was considered by the Risk Committee as part of its ongoing development of the risk framework.
Right.
It's not final. That's the whole point.
And so, and you probably already see this point, but just to explore it. If we take, for example, I can't read it, it's too small, mine. It's under people 2.5, number of serious misconduct terminations. I'm just picking this one sort of because I can ask you a question, it will work.
Yep.
And under target, it's got 5. So I take it that if there were more than 5 serious misconduct terminations in a month across the group, we'd see a red line there, a marker or something like that.
Well, and the benchmark that was set for this one was actually the number from the previous year. So the other conversation I think we have, and this is the point of granularity, and it goes to the culture piece, and this is the conversation, this is why the Deloitte report, where it talks about all of these elements working in congruence, we actually have to ensure that the metrics and the targets we set are consistent with the new culture plan. So it may be last year's number is okay, it may not.
I'm not asking you about how you specifically set this one. The question I really have for you is, at the level of the group, you've decided that for whatever reason 5 is the metric. But if there's 4 at Burswood in a given month,
Absolutely.
you'd want to know about that if you were the director.
Absolutely.
And wouldn't you want to know about that as well as the director of Crown Resorts?
Yeah, and so when we get the reports, I mean, this is my point about this being under development. When we get the reports, we have in the risk committee. So at the moment, we also get like a compliance report where we actually have the compliance officers talk to us about compliance and particular events and instances. And to your point, I would expect to be told if the majority of those are at Burswood. Absolutely, I would. The challenge is getting this into a reasonable framework so then we can break it down across the properties. So then you can actually get that level of granularity. This is the point about we need the granularity.
Now, can I pick up something else that emerged from Mr. Deans's report to the Victorian Royal Commission, which was, he said words to the effect, there was an expectation there would be a process involving management and either the board of Crown Resorts itself or at least the RMC in a discussion, perhaps of a day's duration, possibly with an external facilitator, in which risks are dealt with in a very comprehensive way, including what are material risks, the risk matrix, and presumably also perhaps setting the metrics that you've been discussing. Has there been such a meeting during your time as a director?
Yes, there has.
And when was that?
So we've been through several times the list of risks. We went through it most recently in great detail. I want to say the last risk committee. I might be wrong about that, Mr. Futrell, but that included all of the both the directors with regulatory approval, but the observer directors as well. I mean, one of the things I wanted to do was make sure that we had the benefit of their experience. So we have been through that in great detail. It didn't go to the metrics. My view is it was talking about what the risks were, and we're not yet at the point where I think that metrics process is worthy of picking apart with the whole board, but we will at some point.
Do I understand that to have taken place this year?
Oh, yes, definitely.
Right. That'd be a convenient time.
It would. Ms Halton, we break now for an hour, so we'll come back at 2 p.m. our time, which would be 5 p.m. your time.
Thank you.
All rise.